now just touch on the buyer side, and the good news is I'm not going to go through all of that from the buyer side. I'm just going to just touch on a few things. But as we discussed with the seller side, you need a strategy. The first one is you need to look for businesses that you know about. Everybody probably knows that one, so we'll pay for quality, stage your investment. So this is really just a mirror of what I've said for buyers. The buyer's going to try and get you to invest in the process and get you, wanting to do a deal. Be calm about that and just stage it. Go exclusive early and take over control of the process. So there you go. It's pretty much a flip side. But there's perhaps a few more important things that you need to think about as far as before you even go out looking for a business, which is, first of all, how you'd structure a purchase. So obviously you want to start with an asset purchase, but you also need to think about what you're going to buy the business into. So I'll just touch on a few of those. So small businesses, go and see your accountant. If you are an accountant, they'll come to you. Companies, trusts. You might want to think about a dual business structure, and I'll just show a diagram of that, but that's where you buy the assets into one entity and the business into another to create some of that asset protection. There's issues about GST there if you're selling everything that you need for a going concern and those sort of issues that no doubt you're all aware of. If you're acquiring an entity, so you're acquiring an existing company, so you're doing an entity purchase, then I always suggest that you set up an acquisition vehicle. That's a special purpose company that bolts on the bottom of, that you'll bolt on the acquisition on, and I'll once again just demonstrate why that's the case. And also just make sure it's fundable. So choose a structure that the banks are going to be happy with, or if you're going to get outside investment in, they're not going to invest in a family trust. So you need a company if someone's going to be putting equity in there for you, or a unit trust maybe. So this is just a quick diagram of a dual structure. So it's pretty obvious stuff. You've got business assets on one side being used by an operating business on the other. When you're buying, you want to allocate as much of the purchase price as possible to revenue assets. So that's plant and stock, because you'll get a deduction for the cost value of what you paid for the plant, and you'll get a deduction for what you paid for the stock. The seller, on the other hand, is going to want to attribute written down value to the plant and a low market value to the stock, because they're going to be getting those assessable balancing adjustments that they don't get any capital gains tax concessions on. So you've got that tension. And one way to sort of deal with that or not deal with it is to actually not have an apportionment in the agreement. And then both sides have to have a reasonable basis for how they do their apportionment. You just need to know that if you just automatically put it all to written down value and the tax office comes looking, you better have some basis other than the fact that that was my written down value, because the tax office will also see the purchaser's side where they've gone out and got Mason Gray Strange or a valuer to come in and value it all at twice what the written down value was. So just be aware of that. So I'm just going to show a quick example of an acquisition vehicle. So James is going to acquire it, and he sets up Acquisition Co, and he buys BTL Proprietary Limited from Malcolm, which has some assets in there and it has some goodwill. Now the asset cost is written down at 2.25, and the goodwill's not on the balance sheet because of course it hasn't been paid for by the company. So James goes and raises $4 million to buy those particular assets, and you think, well, he's just bought a massive tax problem because he's bought something worth $4 million and its book value is 2.25. But because he's set up an acquisition co, or if he's a listed company, he's set up a company or acquiring it into a particular division, he can do what's called tax consolidation, which I'm hoping some of you are aware of or do a lot of, which basically means that the $4 million that he's paid can be pushed down and allocated according to the market value of those assets, so that when he starts day one, he doesn't have any inherent tax problems. So a lot of people would say, don't buy the entity because you're buying all these low cost bases and no cost bases, etc., no tax costs. That is one way to start from the value that you buy in. Now, of course, if James then sells the business for $8 million, he's got a new $4 million problem in his own company, but at least he's dealt with the starting problem that he would have otherwise inherited from Malcolm. Hopefully that's reasonably clear. The funding options, I'm not going to go into these in any great detail, but the obvious ones are equity from family, friends, your savings, debt, and also it's not just plain debt. Think about things like leasing, plant and equipment, those sort of things. But the one that tends to be one that certainly comes to the fore in SME type transactions is vendor funding. And so I'll quickly just talk about some of those aspects. First of all, raise it early if you're going to need it. So put it on the table. It's also quite handy from a buyer's perspective because it's like a retention amount. So if you're going to have an offset later on and you haven't paid all your money, then it's going to be a lot harder for the purchaser, for the seller to get that money. And so you're not arguing about money you've already paid, you're arguing about money you potentially need to pay. And you need to consider the term, interest rate, security, and step-in rights. So my quick view on that is the term should be whatever's fundable, whatever the business can afford after tax, some sort of thing like that. It should have an interest rate that's higher than the rate that the buyer can obtain in the market, so there's an incentive to pay you off and replace it with bank debt. And I think it should be secured at least against the assets, but there should be some sting against the individual themselves if possible. And the reason vendor funding works is because the person who sold you the business is probably the best person to step in and rescue it if all goes pear-shaped and they can't actually pay you that vendor funding. So I'm going to be very brief here. Review the IM, pretty obvious, work out whether it's affordable. When you respond to an EOI and binding offers and non-binding offers, keep things open. So keep talking about subject to due diligence. Justify price and say that it might change and it might go up so that you haven't cut yourself off by starting at a really low value and then having to miss out on the opportunity completely. And you and your advisors look for options that you can create for the seller, because the seller might be not thinking outside the box as much as they should. Due diligence, take time, ask the obvious questions. Look for an opportunity. It's really an opportunity to establish value. A lot of people go into due diligence thinking it's a reason, looking for reasons not to do a deal. I think it should be a combination of looking to find true value and then work out what you're going to need in order to mean that you can actually walk away with that true value as far as those warranties, indemnities, deal structure, those sort of things. Be prepared to walk away and get your hands on some checklists and questionnaires and standard warranty lists. They're reasonably widely available. Inspect source documents. So this means look at the invoices, look at the bank statements. If the person's telling you there's a lot of cash coming into the business, go and sit in a cafe and watch the cash. Turn up each night, count the cash with them for a month or a week each month for say 3 months, whatever. Obviously it's a timing issue, but these are the things that you need to do. And then manage your advisors so they don't go crazy and they don't overinvest in the process, and also coordinate them so that nothing gets missed. And what will come out of that is a due diligence report, and that's really to get the sort of the go, no-go type decision. And it should have things like price-sensitive discoveries, warranties that need to come out of that, and then your conclusion. So that the SPA, we've talked about that. Don't buy a business without a restraint. Hopefully that's obvious, but I do see instances where that's not the case and it usually ends in tears. People always ask me what's reasonable for a restraint. Restraints tend to have 3 components. So what over? So if you're buying a business, I think you can go as far as to say you will not compete with me. Rather than you won't solicit, which is a bit washy, you will not compete with me. You will not approach my employees. You will not approach my suppliers. Not just your customers, but make it a proper restraint over everything you need that you're buying. How long? My rule of thumb is start with the time over which you've calculated the profit. So if you've gone back 3 years or you've used a multiple of 3, then go forward at least 3. Now it's not going to be enough time to recoup your money, but it's definitely reasonable. Then you might then justify a couple of years after that. You're going to be lucky to get away with anything more than 5, but you should be able to get 3 for those sort of SME type businesses. And how wide? Really, we're talking about the geographical space there. So I always start with the markets you're operating in. So you might be selling a little bit in Newcastle, you might be selling a lot in Sydney, whatever, some in Perth. They're your markets. So rather than just say 20 kilometres, blah, 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 start with a statement that the markets that I operate in. And I think what's even better than a restraint is a properly worded clawback, because what that is it's like an agreed outcome if somebody takes one of your clients. So in the accounting profession, if you've bought or sold fees, there's usually clawbacks if you lose customers or the person who sold them to you starts providing service to those clients. The good thing about that is that it really takes away having to prove what your loss is when somebody breaches a restraint, and even having to
prove the breach in the first place. If a client goes and starts working with the other person and they need to pay you X dollars, then it's done and dusted, and it's a relatively easy way to go. But once again, it's something that you very rarely see in sale and purchase agreements. But I think it's really quite a good way to do it. Ladder clauses is a little bit less of an issue in New South Wales because there's legislation that will to a certain degree, make it reasonable. But because you might see these clauses, I'm just going to quickly touch on them because you might go, what are the lawyers on? It'll say something like for the longer of or the following areas: Australia, New South Wales, Sydney CBD, whatever. And the idea is that the courts have said if something's unreasonable and we strike a part of it out, it's still got to make sense. Because if it doesn't make sense, the whole clause evaporates from a legal perspective. So the purpose of these clauses is the courts go, for the longer of 5 years is unreasonable, so that's out. But the clause still makes sense because it now says for the longer of 4 years. But then they go, that's unreasonable. Oh, it still works. It's for the longer of 3 years. So just if you see those things, it's not crazy drafting, that's actually the purpose, that's how they work. So this is more of sort of business stuff post completion for the purchaser, but taking control and responsibility, confirming insurance cover, getting your banking arrangements in place, and then starting going forward. Get your business plan. You start with the IM and then turn that into a business plan. So you're sort of swinging between the ropes. Register your transfers. Think about whether you need to stamp assets to get proper title to them, and then get your money's worth. So get to know your new clients. Have staff and your own time dedicated to getting out there and actually meeting what you've bought. Keep the key staff, integrate them. Clearly define business-wide roles. So the new staff take on aspects of the old business. If you're going into a merger situation, your staff go into theirs and you get some of that mix so that you're keeping those key people. Address conflict directly and early. Consider ditching what's not working. So if you buy a business, there's elements of it that aren't working or you're not into whatever, you can get rid of them and get some of your money back. And then honouring the cultures and heritages of both businesses. Often you'll see a great business get acquired by another business, and there's the business that got acquired had a great history and whatever, and it was really good in a particular area, out west or whatever it was, and that gets destroyed and trampled on through an ego process internally, and you've really destroyed a lot of what you bought. So as an advisor, starting early with your clients is obviously a great idea to the extent you can get them in there. But I just think every time you hear the word succession or selling out or estate planning or whatever it is, for every person who needs to sell a business, you need to find a buyer. And I think there's a lot of talk about business succession at the moment, but there's not a lot of talk about growth strategies. So as an advisor, I think there's a massive market out there to position yourself as a growth strategy sort of person rather than a business succession person, because everybody's talking about business succession. And then look for quality acquisitions for your clients and among your clients. So it's a form of referrals really that you can develop internally. And then finally, obviously we don't put breakfast on for nothing. We can help you with the exit and growth strategies and making that part of your practice if you're an advisor, or assisting you if you own a business. We can help you prepare your business for sale and the sort of issues that we've talked about as far as locking down those contracts and really making your business sale ready. We can help you identify businesses to purchase, obviously from a legal perspective, that's what we do. We can assist you with your IM, disclaimers and what should be in there and how you manage the warranty and disclosure process. And then obviously we can implement your transactions. And we're happy to train and coach junior staff on these issues if that's something that's interesting to you as well. And that's the talk. Any questions?